let us know. Unexpected family complication. And so we're actually shy of a quorum. So Jane and Victor will not be here today. The only thing I can think of is perhaps one of my staff who is not presenting right away could talk to what's floor session right now? Yeah, so we can't loop in a legislative member because they're in floor session. So I think we'll just have to proceed as a subcommittee and present minutes of the provisional decisions, and they can be subject to ratification in October, when hopefully we'll have a quorum. The only good thing about that is we don't have to call the roll, since votes today would be meaningless. We could use them as guidance on the issues that aren't final decisions, but any final decisions we'll have to go back and approve in October. That's fine. I don't think there's anything completely critical that's going to happen today. No, I can't do that.
You were gonna, Brian, question?
Yeah.
Should we at least stick around until the special presentation at 10 o'clock?
Yeah, you should stick around throughout the meeting. I think that
No, I mean, like, we have no incentive to wrap up early because we have that special thing at 10.
We also have one at 11:30. That didn't make it to the agenda, but it's scheduled.
Okay.
So
do we need to postpone the election of officers?
Well, yes, much as I hate to do it. Hi, we're joined just now by Sharon. Come join us. You missed
Hello. So nice to meet everyone.
You missed the Falderall. And we don't have a quorum, so this is like a pretend meeting.
Oh, okay. That's
So-
all right.
Okay,
So this is Sharon Riley, who the commission
Sharon.
decided to make my successor. So you'll be seeing a lot more of her. And she thought it would be a good idea, since she's in Sacramento, to join us today
That's
and
awesome.
just say hello and introduce herself.
Sharon, unfortunately, my reign of terror as chair is going to extend over one more meeting because we can't elect officers today.
Okay, yeah, I was looking at the agenda. I saw that was on the agenda.
Yeah.
Well, you could voluntarily step aside and let the other
Yeah, I'd
David
love to.
act.
No, I'm too far away for that.
Not today, I mean in
I
October.
can
I
take
can't
over
see-
next meeting.
Okay,
I can't seize control from the wrong side of the equator.
yeah, that's true. All right, so I guess we'll move through. There's no point in asking for opinions on the minutes. I mean, if any commissioner sees anything that they think needs to be changed, we can take that into account and present it when we present the minutes again for a vote in October. Anybody have anything they want to raise? No? Okay. Other than
Brian,
that,
I have one non-minutes related thing.
all right.
I just, to the extent that it matters, I just wanted to note for the record that I am presently in room 129 at Berkeley Law in Berkeley, California, in the posted location. I have the agenda posted on the door. The door is unlocked and I'm here by myself.
You are fully compliant. Well done.
And
So you're in a-
I would make the same representation at the location noticed in the notice of meeting.
Yeah, we're good. David Carrillo, you're in a Zoom room? I didn't know that was going to be the case.
Well, all the classrooms are outfitted with this kind of setup. So
Okay.
like, it's intended for guest speakers, but it works great for Zoom meetings.
Great. Okay. With the commission's consent, I'll move on to the executive director's report.
Please do.
So the next meeting is in October. Before that meeting, we're intending to take Sharon on board in a special assistant classification so that she can shadow me for a month before I leave. So when the October meeting comes around, she'll be on staff. So the meeting today, as David Creel mentioned, we have a 10 o'clock time certain for toxics material, and we've got an ASL translator that we're going to have to figure out how to promote to being a participant. That'll be fun. And then at 11:30, we have Professor Ziegler of UC Davis Law is going to be making a presentation on aspects of the study that the ERA study that Kristen is staffing. Reappointments. I have talked to the staff in the governor's appointments office. He indicates that he's on track to address our pending vacancies. And expects to have those resolved by the end of October. So you're nominally, your terms end on October 1, but you're allowed to hold over for 60 days. And so you'll be able to attend the October meeting. And then before the end of October, I'm told we should expect that any reappointments or new appointments will have been resolved. And yes, they're one of them.
Yes, ma'am. Those are valid, even though the Senate hasn't confirmed us yet. Will not have confirmed us yet.
You mean the holdover?
Yeah. Well,
You have been confirmed for your initial term, right?
yes,
For the term you're currently serving?
correct.
Yeah, you get to continue serving without Senate ratification, as far as I know. During this statutory holdover period, which is automatically terminates after 60 days.
But that would take us to the end of November.
Yeah.
No, legislature isn't going to be in session again until January. So they won't be able to confirm anybody until January. So I'm just curious as to what happens.
We've had people in this posture before, and it's never been raised as a problem.
Okay.
I don't know that the Senate ratification process has a hard deadline for when it has to happen for appointees.
That was my question.
Yeah, it's never been raised with me. I've never looked at it.
Okay.
I hope not. So it wouldn't make sense, given the way the statute.
Understood.
So I assume we act as acting pending Senate confirmation.
Sure.
So if Rick and I get reappointed and the Senate doesn't act on us until whenever, then we're in an acting status.
Yeah.
I would think.
I believe that's right. Just as a new appointee can serve before the Senate confirms them.
Okay.
You know, as soon as they execute their oath of office, they're in the office. They can get bounced if the Senate says no, but I think that period prior to the Senate's action is they're permitted to act as in the office.
Got it. Thank you.
So the other thing I was going to share, not unexpected, but unfortunate news that King Hall has finally decided that they have a higher need for their space than having us in their space. And so they're not electing to extend our contract for another term. So we are in the process of thinking through where we will reside. And that includes, I think the most complicated piece is who will provide us with web hosting services. That was one of the most valuable things we got out of the deal with UC Davis. So their students are great too, but their IT department was really stellar, and it was a great service that we had all of that bundled by one provider and could rely on them to provide security, et cetera. So we're in the process of figuring out an alternative to that. We don't have a hard deadline for that. And so I'm not anxious about it. And I think we'll get it figured out before they decide to push us to finish it up. That's all I have for the executive director report. David, David Creel, you're chair, right? You want to call the next agenda item?
I am chair, and let's go to the next in order, Mr. Executive Director. I
That
suppose I should also say that the meeting is called to order at some point.
As a subcommittee.
Yes, as a subcommittee. Yeah.
Okay. Steve, will you watch the clock and let me know if we get to the point where we need to figure out how to integrate the translator? I think the next item is commissioner suggestions. Any?
I suggest you move the commission to Berkeley.
Okay, noted. You want that in the minutes?
No,
Okay,
I'd love to have you here if we can make it work.
well, we could move all of our storage there. You want to give us a storage room?
I'm sure the Bancroft would have a space for it.
Yeah, okay. We're reducing our footprint as much as possible. And there is a sort of a bare minimum of physical storage that we'll need. Otherwise, we're talking to some folks about like just hoteling space so that if staff needs to be physically present in an office somewhere in Sacramento, they would have a room that they could sign up to use. But we may reach the point where really all we are is a long-term storage unit and some hoteling space at another agency. This is news to Sharon. Or we could lease some space and have an actual office, but our experience working remotely has been pretty good. And we really don't use the physical space for much of anything. So that's a long way of saying probably doesn't make sense for us to be in Berkeley because the needs that we'll have are sort of convenience-based for the staff, and none of the staff are anywhere near the East Bay.
Is it worth going back to the archive to see if there's at least a partial deal there? I know
The
that
library, state library.
Yeah, the state library or the
Yeah,
archive.
I'm
Either one
talking
of
to
them is
them.
kind of a natural home for the stuff.
Yeah, I'm talking to library about some options, but we're not progressed to where I can predict anything yet. Okay, so the next item would be the election of officers. I assume we're not going to handle that today.
I suppose we have to
One af-
table that.
Yeah, well, I'll just present the same memo at the next meeting. Same with meeting schedule, I assume. If we've got just we don't even have a quorum, I don't see the point of trying to fix the schedule, but we're looking at January onwards, so doing it in October is plenty of time. I would recommend that we just push that item over to the next meeting as well.
I think we have to table that too.
Yeah, legislative program. Mostly just an informational update. There is one decision. The status of the bills is they're in decent shape. The stock cooperative transfer on death deed bill has been chaptered. So has the fish and game miscellaneous improvements bill. That's been chaptered. There's a note on the fish and game bill, which is that it was discovered that there's another bill that conflicts with some of the provisions of our fish and game bill, but the author of that other bill agreed to take steps to coordinate. So if they follow through with that, what they would do is import our language into the same provisions in their bills. And so we wouldn't get knocked out. We wouldn't be completely superseded. Our effect would go into law. The administrative subpoena bill it's cleared the policy committees in both houses. It's pending in the fiscal committee in the Senate. And it's been put on a slow track in that committee because there is a stakeholder group that is talking to the author about possible amendments to the bill. I have been involved in those discussions, but I'm not at liberty to share them publicly. They're between the author and this interested group. So I can tell you as much as I've just told you and nothing else. And then the last bill was the trial court unification, trial court restructuring bill. And this is a bill that, as we explained at a prior meeting, that used to be all of our content in a single bill with nothing else in there. The bill was dedicated to our proposed law. The committee, who was the author, decided that they needed that bill for another purpose. And so they gutted it, took our content out, and then they put our content into their omnibus bill. So that's a bill that was already moving along that had a whole bunch of different things, and our stuff is just one more tranche of different things in that bill. Kristen is staffing that. She kept an eye on it. She noted that there were two significant omissions when that amendment was made to put our content into the bill. One was they dropped out a change we were going to make to a penal code provision. And it's our intention to ask for that to be reintroduced next year. The other is a little more complicated. If you remember, this is trial court restructuring, trial court unification. We were touching and repealing a lot of provisions that related to court employee benefits. And Barbara recommended and the commission adopted a very conservative approach to those provisions so as not to accidentally adversely affect somebody's benefits. So the first layer of redundancy was they were repealed with a 50-year sunset date. And the assumption is actuarially that they're not going to be affecting anybody in 50 years. The second thing was each section we repealed had its own statutory savings clause that said the repeal of this doesn't affect anybody's benefits. And then we had a bill-wide savings clause. So it was an uncodified provision at the end of the bill that said nothing in this bill affects anybody's benefits, right? So we said it 3 times, so it must be true. When the committee put our content into their omnibus bill, it no longer made sense to have a bill-wide uncodified savings clause because it would apply to stuff that wasn't our stuff. And it might not make sense in that context or have unintended consequences or whatever. So they left it out. Kristen, in consultation with Barbara from beyond the retirement wall, thought it through and concluded that we could live with that the 2 levels of redundancy were sufficient. And reinstituting this code-wide thing just was impracticable at this time. We could maybe do in the future, but again, very difficult drafting, weird statutory provision. So it's our recommendation that we tolerate that omission, but the only consequence is that we will have to issue some revised comments that mention it to strike the language that mentions it. So maybe I didn't need to explain all that because there's no quorum, but that's our intention. We can productively hear any concerns that you might have. Otherwise, we'll just present it for decision at the next meeting. It might be easier actually if you provisionally approved it as a subcommittee, and then we could just have a ratification vote.
Do we need a motion?
Move to approve
Second?
provisionally.
Second.
I actually will call the roll then, but only those who are actually here.
It won't take long.
Korea,
Aye.
excuse me. Hebner,
Aye.
Jenkins,
We're calling roll or we're
we're calling on the motion
on the motion?
to
Aye.
provisionally approve it as a subcommittee. Simpson.
Aye.
Okay. So what?
Should we take a poll of the commissioners with respect to the meeting schedule and see if there's any problematic dates on there for the commissioners that are here?
Why don't I just say this? We'll present the meeting schedule meeting memo again next time, but if anybody has any concerns about it, just email me separately and I'll take them into account offline. Okay, so that's legislative program. We're going to provisionally approve to make those comment revisions. How are we doing for time?
11 minutes till 10.
11 minutes till 10. Da, 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 da.
It's a good time for me to.
So,
I'm sorry, 11:30 is the,
11:30 is the professor.
and is there a way I can log in versus
Yeah,
logging back?
yeah, you
Okay.
just use the credential I
Okay.
sent you at the outset, yeah.
Thank you.
I guess we can't make a decision on this, but the antitrust memo, in addition to talking about my plans for the October meeting and presenting an article that a organization commented and suggested that we read. There's also the discussion about hiring a consultant. And my proposal is to hire Cheryl Johnson. Cheryl is here in the audience. I could promote her if anyone has any questions for her. We can't vote to approve the contract at this meeting, so we're going to have to kick it over. But I could just hear if you have any suggestions or concerns about that decision. It was a product in part of the hiring process we went through for my successor, where we realized that to the extent we need somebody who's a specialist in antitrust, we maybe didn't need to employ an executive director who has that expertise. We could hire a consultant who could work closely with us to provide that knowledge and advice. And so acting on that, I thought through the possibilities. As I mentioned in the memo, one of the things that I think especially commends Cheryl for the position is the decades of experience she had as the editor-in-chief in the California State Treatise on Antitrust, which includes the Cartwright Act. So not only does she know this law inside and out, she also has been in a position where she had to wrangle a team of experts who were submitting writings and then work to sort of coordinate and consolidate all of that information and put it into a form that is sufficiently neutral and to be trustworthy, to be a treatise that attorneys can turn to and know, you know, this is a good authority on this law. I don't have to worry that there's a hidden agenda in here or anything. And so given how polarized the community is in the antitrust practice area, I thought the idea of having somebody who had worked for so long from that position of committed neutrality was a strong qualification. That, you know, when I think about all the other people, there are a whole bunch of people out there who could bring excellent information and knowledge and experience, but it would be really hard to find somebody who wouldn't be subject to concerns that they were channeling a particular perspective because of their own career and practice experience. So that's why I think Cheryl would be an excellent choice and is my recommendation. I wish we could vote to approve it now because the contracting process is going to take a long time. But I think October would be soon enough. Does anyone have any questions or concerns about that?
No.
Nope.
Okay. I don't know if that's an item where it makes sense to try and get a provisional decision of the subcommittee and present it for ratification as opposed to reiterating this presentation at the next meeting. Do you have any opinion on that?
I think we
I
have to
would,
wait for quorum.
Yeah.
Just wait and re-up it at the next meeting?
Yeah,
Okay.
I think we have to.
All right, sorry, Cheryl. The good thing is I don't have to figure out how to promote Cheryl to being a panelist at this meeting on this unfamiliar piece of equipment that I was not introduced to.
Because I think we'd wind up having to do the same presentation twice if we did it today, right?
Well, I think we're going to have to make the same presentation twice, and I think that's okay, because I think that that's a decision that it makes sense to have the fullest representation of the commission before authorizing it.
Right.
So how are we on time?
6 minutes till 10.
6 minutes to 10, so maybe it'll take me 6 minutes to figure this out, and then we can just start if those folks are present. Were we told what the translator's name was, the replacement?
Her name is Audra and says she's available at 10 a.m. and she's going to be using the link that you sent, which had the name ASL translator on it. And I don't know if it was.
Oh, okay, and that was actually a panelist
Yeah.
credential, so I think we just have to wait a couple of minutes. And I'll preview that when we get to Kristen's topic, we're not going to wait for the professor. who's coming at 11:30. Kristen will start her topic as soon as we're done with Steve's. And we'll see how far we can get through with that. I imagine we can get through with that before 11:30.
Sure.
And then we'll take a break and come back, reconvene at 11:30 to hear the input from the professor. And then that will be it for the day, I think.
Another possibility is depending on how soon we're gonna wrap up, we could try to reschedule for October.
Ziegler?
Yeah,
It's such a full meeting. The October meeting, we're having 4 presenters on antitrust. One each from the authors of the US bill on antitrust that got a lot of press attention, and the New York State bill, both of which were mentioned in our resolution, and one each of the opposition to those bills. So there's going to be sort of a 1 hour slot dedicated to each bill, which will feature a presentation, 20 minutes first by the proponent, 20 minutes by the opponent, 20 minutes for commission questions. So from 10 to 12 in October, we're going to be solid with antitrust discussion. So adding another speaker to it, I think is probably, would be like straining it a bit. All right, let me go see. Well, I guess she's supposed to come in as a panelist. And we got 4 minutes. If you want to take a 4-minute break, go for it. If I could get coffee in 4 minutes, I would. But I won't, because I can't.
If I could get tea in 4 minutes, I would, but
So I think we just have to wait until the translator pops up.
Okay. So Sharon, did we work together?
We did.
Yeah, that's what I
Yeah.
thought.
An education.
Yeah,
Yeah, that was my former area of expertise.
yeah, mine too. Now former, because I've been out for 6 years now.
Good for you.
Yeah.
Yeah, a lot, I think, has changed with Prop 98 since I used to write all those
Oh, yeah.
opinions.
Yeah. Did you see what I did to name the article that all the Prop 98 implementation stuff is in?
No, what did you do?
I named it after sort of the godfather of Prop 98.
Gold, is it? No,
John Mockler.
Mockler, yeah.
The John B. Mockler School of Finance.
I thought you weren't allowed to do that anymore, that kind of tombstone. That's what I had heard from Diane.
As long as you get the votes. He passed away in 2015, I think. And so it was something that he
I was aware of
he
that.
did authored most of the proposition. And, we worked on you were there when we worked on the implementation
Mhm.
statute for.
Yeah, I joined it. So Jeff Deland.
Yeah.
Was doing Prop 98. And then when I joined, somehow they figured out, oh, she knows how to do math and she's a lawyer. So she's a good fit.
Well, I didn't vote for it though.
I'm Kristen, by the way. Hi.
Nice to meet you.
Nice to meet you.
Nice to meet you. So excited to be joining you soon.
Yeah, really nice to
Great
meet
to
you.
meet you. Thanks for coming.
Yeah,
Looks like there's so many interesting topics. I'm so excited.
All variety.
big variety, yeah.
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 Have you started to study antitrust law yet?
I took antitrust, just a couple years ago when I was in law school. And since then, I've been trying to keep up with some of the memos. But I'm really excited to work on it. It's a fascinating area of the law, especially as with all these emerging issues we have now.
Yeah.
New challenges.
Mhm.
Yeah. One of the nice things about the Zoom that we've been doing is that those presentations that we had, those PowerPoints, they're all stored on YouTube. And we have the slide decks, so you can just look at PDFs if you prefer that. But if you want to watch the excellent presentations that went with the slide decks, they're all there. Just 6 or 8 hours of antitrust introduction. All right. 10 o'clock on the dot. Make sure she didn't come in as like. Well, I know the link was ASL translator, but were you given a name?
Audra.
Audra. And we don't have an Audra.
Audra Tipton.
So an ASL translator's name is Audra. AUD, I see.
Audible, yeah.
Yeah. Oh, and I don't even see.
Oh, there we go.
Here we,
she is.
here we go.
Hi.
But I don't know about, yeah, thank
Are you
you.
looking for blue? See,
I am looking for blue.
Yeah.
Blue is not yet with us. Hello.
don't bother you.
Well, I guess that doesn't matter, huh? Are you ready to go? Yes?
Yes.
Okay. So this is first, what are you waiting for? What?
Hearing.
Can you hear us? We
Can
can't
she
hear
not
you.
unmute?
She is on mute. Let me see about that.
Oh, sorry about that.
There you go.
Oh, okay.
There we go. Okay.
Good morning. Can you hear me now?
Morning, yes, very good.
Perfect.
Are you able to hear us well enough?
Yes, I can hear. I can hear. Yes.
Okay.
So can you tell what
It doesn't look like Blue is here.
we,
But we are at a scheduled time, so maybe I'll check my email real quickly. Maybe they had to substitute somebody else in at the last minute.
Is the deaf client here?
That's what no, but I'm checking to see whether I got a message about that.
Okay.
I don't mean to be rude, but when I present, I'll just look this way. Yeah, that's what Dan, having speech to my back, but not much I can do about it, I guess. Putting in 20 years and stuff.
Trying to keep us lined up so you can see us all.
know.
Keeps it.
I'm kind of screwing you up, I'm sure, here, but trying to get a spot, the angle in here.
All right, so if there's anyone else here from DTSC who's substituting in for Lou Aldrich, could you raise your hand? I don't know if this is going to show me. No, not seeing it.
Well,
We paid for an hour. The person is not here yet, so we're not quite ready to go, and I'm not sure what to do if they don't show up.
It will be on the video.
put it
too,
on the
though.
video, so
Yeah, that's true. It will be on the video. I'll be out of the office today. Okay. Well, I guess maybe just proceed and Blue will have to watch on video. Yeah, okay, David, does that make sense? David Carrillo? All right.
Sorry, I was muted. Sounds good. Proceed.
All right, Steve.
All right.
Go for it.
Good morning, everyone. We have two memos on the agenda from this study, which, as you know, relates to the proposed non-substantive recodification of two very lengthy chapters in the Health and Safety Code. We've done one chapter already, and now we're starting on the second chapter. The first memorandum is Memorandum 23-38, which presents the first cumulative draft relating to this chapter. A cumulative draft, as a sort of a refresher, because we had a number when we were doing the other chapter, is just a compilation of recodified provisions that the commission has previously approved for inclusion in a tentative recommendation. So the cumulative draft puts them all together in a single document. It's meant to just be a reference for commissioners and anybody else who wants to see the progress of the proposed recodification. And so the memo doesn't really present any decision points at all unless someone has something that they want to raise. It just summarizes in general the process about putting together the cumulative draft, which will be updated and then presented again frequently. And it also identifies any needed revisions that had to be made to provisions that were previously included in or approved by the commission provisionally. And that's what this memo does. And those needed revisions are outlined on pages 2 and 3 of the memo. And my apologies, but in another review of the memo, I noted a typo on page 2. I have no line number, but in the middle of the page, the second bullet point under legislative updates, there's a reference to proposed section 60525. That should be 60250. Other than that, does anyone have any?
Before you go on, I'm looking at the video and I can't see the video for the translator. I don't know if that's a problem.
Oh,
Yeah.
This meeting might be cursed.
What
We
meeting?
should maybe go get donuts.
how long
Wait,
ago?
she's coming back.
Here we go. Excuse me. My apologies. My apologies.
That's okay. Should I go? How much should I repeat?
Just your edit
It dropped out when you were talking about the type.
typo.
Excellent. Okay, so I noticed a typo. My apologies. In the middle of page 2, the second bullet point under legislative updates, there's a reference to proposed section 60525. That should be 60250. Other than that, anyone have any questions or comments about the needed revisions that are identified in the memo?
Nope.
Okay, anybody have any questions or comments? I guess anybody have any questions or comments about the memo at all, the cumulative draft or anything else about the cumulative draft besides what's presented in the memo?
No.
No, that's good.
Okay, and do we, I can't tell if we have anybody in the audience that wants to, sorry.
I don't know that I can tell either. Anybody who wants to be heard on this topic should raise their hand. Nothing.
Okay. All right,
So do
so,
a tentative, do you want to do a tentative?
Yeah, I don't want to present these documents again. Why don't we do a vote on provisional approval so that at the next meeting, commissioners who aren't here today can review the materials, decide for themselves whether they have issues they want to raise in October. And if they're okay with it, they'll just ratify the provisional approval. Is that all right with Chair and Vice Chair?
Can we get a motion?
So moved.
Second,
All in favor?
Aye.
aye.
Aye. Any opposed? Sounds good.
great,
All right,
okay,
motion carries.
thanks. So this,
Thank you for the translation. That's all we need.
wait, no, we have a second.
Oh, okay.
Sorry, we have a second memo.
My bad.
Sorry.
My bad.
Okay, it won't be much longer though, but, all right, so the second memorandum is 23-39. And this memorandum presents a new set of proposed recodified provisions that you haven't seen before. And for this one, again, we would normally need a motion and approval, a provisional approval, and I guess we'll do it again. It'll be provisional in any event, but so these are provisions you haven't yet seen. It's essentially the next batch that would be included in a cumulative draft and also in a tentative recommendation eventually. Consistent with past practice in the study, I'm not going to go through all the individual provisions, but certainly welcome any questions or comments anyone had on anything that was in that draft. Anybody have any questions or comments?
Just a quick, has the agencies that you normally interact with already looked through this, please? Or we're looking for comments from them now as well?
Well, both. If they were here and they had something to say, that would be great. They are also reviewing these and they are submitting written comments to us, which we're trying to then incorporate. We'll try to incorporate when we present, for example, these provisions in the cumulative draft,
Okay.
we'll be able to have more input.
Good.
So far, that's the way they're doing this. They're giving us comments in writing
Got it. Okay.
before we give them to you.
With the timing, it's not realistic to think that they've done a careful review of this document.
Right.
So typically, the comment would lag a cycle.
Okay. Got it.
Right.
Thank you.
Okay, and
I'll move to provisionally approve.
probably there's no one else on the, we don't have to check again.
It's been moved and seconded. All in favor? All three of us.
Aye.
Aye.
Aye. Any opposed? Any abstentions? Motion carries.
Provisionally.
Provisionally.
Provisional.
Yeah, that's,
Provisionally.
yeah.
Provisional motion. All right, well, that's all I have. Thank you very much.
Thank
Thank
you.
you.
Thanks so much.
Thank you.
Thank you.
Okay, so we've got a good solid hour for Kristen's topic if we need it.
Talk slowly.
Take some deep breaths.
All right.
If we had more people, it'd be a richer conversation, but this is a topic that I think could prompt some significant discussion. So let's take our time and work through it.
Yeah, so good morning, commissioners. Today for the ERA study, you have memorandum 2023-40 and a first supplement that presents a public comment to the approaches that I presented at the end of that memo. So the memo starts off by providing some updates as to recent events that relate, first Supreme Court decisions that relate to some of the topics that we've covered in prior memoranda. So there's 4 Supreme Court decisions from the US Supreme Court that came down that relate to the doctrines that we've talked about. They're each discussed in varying levels of detail in the memo. The first is 303 Creative versus, I'm not sure how to pronounce the name, Alanus, Groff versus DeJoy, Students for Fair Admissions versus Harvard, and Counterman versus Colorado. So I don't know if the commissioners want me to walk through. A lot of these decisions got a lot of attention, and I expect commissioners might be familiar generally with how those results came down, and they're presented in detail in the memo. Probably the one with the most direct relevance for the study and the doctrines that we've discussed previously is the 303 Creative case, which considered limits on an anti-discrimination law that came out of the First Amendment and the compelled speech doctrine, which we discussed previously. I just want to get a sense from the commissioners. Would you like me to go through in more detail these decisions, or? Anyone?
I've read your papers. I don't need a detailed review, just speaking for myself.
Okay. Yeah, I wasn't planning on walking through all of those in detail, but I'll just highlight briefly, I guess, the doctrines that they relate to. So 303 Creative, I've mentioned. Groff versus DeJoy relates to an employer's obligation to provide religious accommodations. It sort of related specifically to an issue about how big a burden could be placed on the employer, and the Supreme Court concluded that the standard that had been previously used was not high enough. So the Students for Fair Admissions case relates to affirmative action, specifically race-conscious admissions policies at universities. Since we've discussed equal protection, and that's the doctrine that the court was looking at in that case, we've talked about it. In that case, they were focusing specifically on race, but it has broader implications with respect to understanding the equal protection doctrine. The final case is Counterman versus Colorado. This is something that was noted just in a footnote for a prior memo, but it's the sort of limits of the free speech truth threats doctrine and how it relates to gender-based violence. This is something that a decision that we hadn't talked about previously, and we didn't really get into the details of the case, but there were definitely a number of commentators that raised concerns about the direction that the court was moving. I think overall, the sense is that, you know, these decisions were not good for sex equality, and the comment attached to the first supplement sort of indicates that. So next, the memo provides a brief update about two pending California constitutional amendments, ACA 5, which would remove the language of Prop 8. Prop 8 is the same-sex marriage prohibition that was in California's constitution that was previously declared unconstitutional. This provision would repeal and replace that language. And I think the language that would be used is presented on page 10. And that has gotten through the legislature and will go before the voters in March 2024. ACA 7 is still a pending measure, but it relates to California's constitutional provision that prohibits discrimination or preferential treatment on the basis of several protected classifications. It would create an exception for certain types of state programs and expenditures of state funds. And the language of that is also on page 10. After that, the memo provides some additional detail and background related to the court's scrutiny of religious beliefs for which First Amendment protection is sought. There were some questions that came up in the commission's May meeting about whether or not courts scrutinize or assess religious belief when those beliefs are offered for protection. The memo walks through the doctrines that we found. I would say, like, there's not a lot of case law there. So in general, just sort of the takeaways were the courts are very wary of trying to assess religious beliefs. There's a quote presented from the Thomas case on pages 12 and 13 of the memo. And I'll just emphasize the final sentence where they say that courts are not arbiters of scriptural interpretation. So they don't want to get into questions about what a religion requires or commands. While the belief must be religious, and that's very clear, the doctrine doesn't give much sense of how you actually make that distinction. So the courts are pretty clear that purely secular beliefs would not get protection. And I think they called philosophical beliefs do not get protection under the First Amendment. But there isn't a lot of guidance as to how you make that determination. And in fact, in some instances, the memo describes the conscientious objector statute, court interpreting that statute. They concluded that actually there are non-theistic belief systems that would be protected so long as they sort of occupied a place in the person's belief system that would be equivalent to a theistic belief system. So overall, it was hard to really kind of get much concrete guidance on how a court might make these interpretations. The beliefs can be personal. So I think that relates to the idea that courts aren't arbiters of scriptural interpretation. Different people within a certain faith might have different ideas about what that faith commands. And you have to rely on the individual who is before you to make that assessment. The cases are clear that the belief must be sincerely held, although that again is something where it seems very difficult to make an assessment. And in fact, courts, there's some indication in the case law that courts recognize that this is a difficult determination to make, because often, while you don't want to be assessing sort of the truth or falsity of the belief, it's hard to separate sincerity from that in some instances. We look back at statutory guidance, because these, like in the religious accommodation context for employment, these issues come up about when a belief is offered and religious accommodation is sought, when must that be granted? And there is some guidance that was provided in the memo, I think on page 17, about how you might assess sincerity. The difficulty is none of that is really concrete, because often it's like they would offer one thing that you could consider, which is whether this is a sort of a new practice, but then they would indicate, but people's beliefs can change. So it really seemed to be a trade-off. And in the end, I mean, the thing that stood out to me was the quote indicates that it largely comes down to a matter of individual credibility. So this is not an easy determination to make. There's a lot of, the courts have seemed to be reluctant to get into these assessments. Oftentimes, the issue is not before the court. Either the sincerity is not disputed or it's conceded and stipulated. So there wasn't a lot to go on in terms of what the doctrine would require. So I guess we'll pause for a moment. Are there any questions on that discussion?
Kristen, that's all very clear. I just have one question, which is, it strikes me that polarity matters. There is sword and shield. A lot of the cases discussed seem to be shield cases, where I have a view myself and I don't want anyone to impair my ability to work or my ability to get an apartment because of that view. What about the sword cases where someone has a view based on biblical references that women are unclean and therefore women should not be allowed to work in that business? Because that's more closely analogous, I think, to the assault on LGBT equal rights. So are you seeing in the cases, sword cases, where courts say, if you sincerely believe that women should not work, we're going to respect and accommodate that?
So I only was focusing on the Supreme Court cases and didn't see anything along those lines. I do think that that's an area where there seems to be a lot of movement right now and a lot of efforts for sort of externally directed religious conduct to be accommodated or to get special treatment.
Whatever you just said, David, we didn't hear it.
Oh, this David Hebner didn't say anything.
Oh, okay. We had some sort of weird compression thing with your video. So in order to understand better what you're talking about the sword, I saw press recently about Baylor University getting dispensation from Title IX prohibition on discrimination, that they, because they're a religious institution, get to discriminate against and not recognize gay student groups. I assume they could discriminate in admissions.
Yeah, so they actually had a long list of different regulatory requirements that they were getting special dispensation from. And it was not limited to homosexuality. It included people who had premarital sex and, you know, women who might have gotten pregnant and been unmarried.
Right. Is that more what you're talking about, David?
Yeah, it's actually using religious belief to hurt other people rather than protect yourself, or to deny other people equal treatment. And I think that's where the rub in some quarters may be on this particular project. And that's why I keep probing about, has the have you seen precedent relevant to California that says if a religious belief is strongly held and compels you to hurt other people, will we tolerate the harm you inflict because you appear to be sincere that God told you to do it?
I think, to me, 303 Creative is probably the most directly relevant to that point.
I think his video is catching up.
Okay. Commissioner Carrillo has also got his hand raised.
David Carrillo?
Yeah, I might have a partial answer. So I agree that 303 Creative is, it's either a low-level case or it's the foot in the door, depending on how you look at it. I think a middle ground or the next step would be in the employment context. So using the ambassador's example, all three of the Abrahamic faiths in the more conservative version would say that particularly during her menstrual cycle, women are unclean. So you could see an employer who has a sincerely held conservative version of one of the three Abrahamic faiths saying, you know, I'm fine with employing women, but they can't come to work for 2 or 3 days out of the month because that would conflict with my religious views. And there's other variations on that same thing. I think that's the next case. I don't think that case has been brought yet. The more extreme version, or sort of where you wind up the end of it, is if someone has a sincerely held religious belief, you know, not just limited to the Abrahamic faiths, although there's a couple of obvious examples there, but any religious belief that requires them to kill somebody, whether they're because they're gay or because they're brown or too tall or whatever. At a certain point on this spectrum that I'm drawing, we're going to have to consider the principle of neutral laws of general application. For example, it's illegal to kill people. It's also illegal to discriminate against people based on their gender, which is the middle ground example that I just outlined. And that conflict between the religious freedom aspect and the neutral laws of general application principle, that's been brewing for some time. And the last couple of cases that the U.S. Supreme Court considered in this area, a lot of the commentators were expecting the court would both confront that issue directly and overrule the neutral laws of general application principle. Neither one of those things has exactly happened yet, but which I think surprised a lot of people, including me. But I think at least the confrontation is coming, and that's something that is at least going to have to get spelled out in a memo, and dealt with at least to the extent of being somewhat predictive in saying that the law is certainly heading towards a conflict in this area, and we don't have the answer yet, but it's coming.
Well, and it's not just the case law. I think in an attempt to avoid conflicting with religious free exercise rights, some jurisdictions have enacted statutes that have carve-outs. So like the Baylor case I was talking about in Title IX, that's based on an express statutory carve-out for religious institutions. And Kristen found that in California law, the Fair Employment and Housing Act has an exception for religious employers. I still think that there are going to be limits.
Yeah, the establishment clause is an obvious limit for how much accommodating the government can be in that area.
Yeah.
So my takeaway from the very important and valid points that the ambassador raises, that whatever we wind up writing, and I have a larger point that I want to make on that in a minute. Whatever we wind up writing is going to have to, sort of draw out the contours of these very thorny issues that are by no means settled and are still evolving. And I think we're going to have to make a tough decision about whether we want to be predictive or not, because I think that's a bit risky.
Not,
Or deferential or not. I mean, there's a range of possible postures. And I
Right.
think that was the last component of Kristen's memo is
Yeah.
The larger question about what is going to be our posture.
Right. And that was the meta point I was going to make, if I can hold the floor for a second, which is that I was looking at the various options that Kristen very wisely outlined. And I agree that the first option should be off the table. Me personally, and my recommendation would be that we should look at sort of a combination of options 3 and 4. But the meta question that I had was, I think I only sort of understand what our writ is from the legislature, like what we're supposed to be doing. And because I'm not 100% sure I understand what the task is, I'm not quite sure I understand what the output should look like. So I think that's a threshold question for, not this subcommittee, obviously, but the full commission to decide on, what exactly are we being asked to do? And perhaps more importantly, what do we think our output should look like? It would be very easy for us to take one of Kristen's memos and just say, like, here's the state of the law. Make some policy decisions, legislature. Good luck. Whatever you decided is probably going to be wrong in 5 years anyway, but have fun, go nuts. And it's somewhere between that and actually like drafting constitutional amendments, like proposed language. I think either one of those extremes is arguably not the most useful thing. So that's why I liked a combination of 3 and 4, because I think the most utility that we could provide the legislature, which obviously is the ultimate policymaker here, is to say, here's the contours of the law, here's the landmines and where they rub up against each other. And here's a little bit of prediction about where the law is likely to go. And most importantly, here's what's possible. Here's what you could do if you wanted to, recognizing the complexities here. And I actually think that last bit is going to be the hardest to write, because I think that's a fairly narrow path. I actually don't think that there's a lot of room for maneuver here.
One thing Kristen mentioned in her memo was, when she and I have been talking about it, I pointed her towards an earlier example that was much less fraught, but it was in this similar kind of vein, which was way back when I first started with the commission. I had this project on whether the rule that applies to wills, which is that dissolution of marriage revokes a disposition in a will toward the former spouse, whether that should be extended out to non-probate transfers too, like trusts, etc. When we looked at that, I realized this is going to affect some kinds of survivor benefits that are governed by ERISA, federal statute on employee benefits. And ERISA is notoriously complicated, and the scope of its preemption is notoriously hard to pin down. But we knew that if we made this rule that dissolution of marriage revoked a beneficiary designation of a former spouse, that in some cases that was going to be preempted by federal ERISA law, and in all likelihood it was going to be preempted. But we couldn't describe what the scope of that preemption was. We knew it was probable, but we didn't know how far it would bite. And so we thought through the possibilities. We didn't want to codify our understanding of current doctrine in California law, because that would be sort of seeding the issue. And it would also be concretizing the current state of the law, so that if future Congresses changed ERISA scope or courts construed it differently, our law would be frozen in time and wouldn't expand or contract with the scope of actual preemption. So the commission's decision was, in its report, to say, yeah, it's likely that there's going to be some preemption here. We do not choose to try to codify it. Instead, our law should apply to the greatest extent possible, consistent with the limitations imposed by federal law and supremacy. And that was all we could, that was, I think, the best compromise we could come up with in that much narrower and less fraught situation. But I think it's a sort of a kernel of a similar kind of posture that we might strike in Kristen's study, which is, we know that there's a risk of other constitutional rights superseding our non-discrimination law. But we're not gonna concede that ground or try to describe it, or crystallize it into like statutory law in California. Instead, let the chips fall where they may. We're going to say what California's law and policy is and let the federal courts figure out whether there are boundaries on that. I mean, Chris and I have talked about these possibilities, and there are different degrees of sort of combativeness with which you can say that. But I sort of think that there's not much more than we can do, because the supremacy clause is what it is, and the doctrines are unclear. And this court is unpredictable in terms of what kinds of precedents they're willing to change.
Well, Brian, you've articulated well my own position, which is why I'm for option 4. I think federalism needs to work when you are trying to elevate people, not just when you're to oppress people. And I think limiting ourselves to trying perhaps transitory Supreme Court might do is not the way we should proceed in California.
Okay. Well,
Your signal is choppy, but what I got, the gist of what you were saying is that you are leaning towards the number 4 option in the range of options. For the reason you said about federalism should protect people, not just hurt people. Yeah.
No, I agree with that. And, like as a state constitutional law scholar, I'm all for being aggressive with your state constitution and then, let it get challenged on supremacy clause grounds, come and get me basically. But even if we go in that direction, we have some pretty significant limits that are sort of self-imposed in California's constitution. And there's 2 that I'm thinking of right now. One of them is like, to the extent that we wanted to recodify things in California's constitution, like one of the specific proposals is basically redrafting Prop 209 in a way that theoretically will get past the voters, because it mostly preserves 90% of Prop 209, but sort of cracks open a door. And I don't know what that door is for, but that's another issue. So, so aside from the specific example of redrafting Prop 209, I don't know what else we would do to change California's constitution to make it more equally protective, especially doing it in such a way that didn't create unforeseen problems that would actually cut the other way. I would be very concerned about fooling around with equal protection. Because I would be so concerned that we would get it wrong, and a California state court should misread it to do something we wouldn't have wanted them to do in the first place. California equal protection law is actually quite robust. I would be worried about harming that unintentionally. The other problem that we have, even within the California constitutional sphere, is that for a long time, some folks, me included, had a view that states could use their own free exercise clauses to basically cabin their state establishment clauses and vice versa. So the idea is that in order to promote free expression to the maximum extent possible, the government needs to stay out of religion to the maximum extent possible. So it's a fairly aggressive form of the Establishment Clause doctrine. That view has arguably been squashed now by the U.S. Supreme Court. So one of the avenues that we could have driven down in a memo like this is to say, California's constitution requires the government to stay out of religion to the greatest extent possible. So, all y'all out there, courts, legislature, policymakers, everybody, the direction from this commission and the legislature is to keep government out of religion and out of religious beliefs to the greatest extent possible. And that way we promote equal protection, because it puts everybody on the same footing. Government is going to stay out of religion and not go around using people's religious beliefs to step on anybody else. I think we can't go down that road after the Montana case. So even if we want to be aggressive with our own state constitution, and I'm the first guy to want to do that, I think there's a couple of, either roadblocks or at least, strong yellow lights in our faces if we want to do that. So that's why I'm advocating for kind of a combination of 3 and 4. If we were going to do 4, I'd have some pretty significant concerns about what exactly we would want to do, whether it would be lawful for us to do so, and I'd be worried about the risks of unintended consequences.
That's helpful. I mean, it seems like Commissioner Huebner, Commissioner Carrillo, you're leaning towards at least the higher end 3 and 4 area. Commissioner Huebner maybe further on 4 than the Commissioner Carrillo. That's helpful guidance for us to move forward. I did want to also add the comment that we received from the Feminist Majority Foundation. I think it's in favor of 4, raises concerns about 1, which are kind of consistent with staff's recommendation that we don't pursue that route. I will say with the federal free exercise doctrine, and just to tag on to something that Commissioner Carrillo was saying earlier about the neutral laws of general applicability, that, right now it's a bit hard to win when you have those neutral laws of general applicability, but that doctrine seems to be contracting. And whenever you have a statutory exception, have some sort of exception trying to, recognize that in some cases, application of this law might not make sense, it seems like you're almost required to extend that exception out when someone brings up this issue.
Yeah, so one of the theories now is that it's going to be death by 1,000 cuts rather than a straight overrule like Roe was.
What do you think, just since we're just talking, there's no decision that's going to be made today? What do you think about the idea that's in Kristen's memo and that she and I have talked about in our discussion of non-discrimination that we give to the legislature and or in statutory intent language, we acknowledge the importance of non-discrimination. Describe it as a fundamental compelling interest of the state, point to provisions in the state constitution about pursuit of liberty and happiness that are guaranteed in the California Constitution that are, require fairness and non-discrimination to be realized. Is that kind of thing worth doing? Does it feel out of bounds for us?
I'm interested in what my colleagues think. I have 2 reactions to that. One of them is, sure, I'm 100% on board with not discriminating against people. But my first reaction is, doesn't the California Constitution already say that? So it's a little bit of a, sort of an empty exercise for us to say, California Constitution already has equal protection and requires, non-discrimination in government and all walks of life. If we want to say that, sure, it bears repeating. But my second point, it bears on something that came up before, which is that, that arguably cuts both ways. The right to pursue your happiness and your liberty, that includes freedom of expression and freedom of association and freedom of belief. So, arguably by, re-emphasizing those freedoms, we're granting some credence to the people who, as the ambassador said, want to use that as a sword. So, that whatever statement we make, regardless of how anodyne it is, it could cut both ways. I'd be worried about that.
Yeah.
Yeah, Kristen, you're doing, I would just say you're doing very good work in a tough area, and I'm enjoying reading your memos. I will keep pressing you for a definition of religion, though, because
There isn't one.
There isn't one. It seems to be devolving into a catch-all for prejudice. And I've got a serious question about what happens when 2 religions conflict. Which one wins?
Well,
or in the United States, is religion actually a euphemism for a very fundamentalist reading of a particular religion? So when we talk about religion, I get confused because there are many of them and they conflict. Which one gets the get out of law free card? Because it can't be all of them.
You know, that is an interesting point, and many scholars have noted the divergent statements in US Supreme Court opinions. Some of them quote some of the founders, like Thomas Jefferson in particular. He has some really good language about you know, the religious freedom principles of the Constitution and its text. They apply to everyone, including the Mahometan, I think was his phrase. But obviously it goes beyond, you know, the Judeo-Christian Abrahamic faiths, and it goes to everything else. So there certainly is language in US Supreme Court cases that supports the very broad view that the ambassador just articulated. Sure, but there's also direct quotes that say things like, "This is a Christian nation." And some of the more recent US Supreme Court cases, perhaps implicitly or somewhat overtly, do seem to have an assumption that when you say religion, it basically means Christianity. So, you know, I say this not to endorse one of these two views, but to point out that the ambassador is 100% right. There is this divergent strain of authority that runs through religion doctrine in US Supreme Court cases that has never been resolved. And there's support for both of those arguments, which is potentially problematic for us.
Well, and I just want to note, I mean, you know, Brian brought up the Baylor issue, but another kind of broader idea is, you know, it's one thing when an individual is asserting religious beliefs, but commercial entities, like, there's a wide variety of groups that are now asserting religious beliefs to get exceptions from laws. And so it's, I think, even harder to pin down what a, you know, corporation believes, even a small one. And so there's a lot of interesting questions about how those doctrines are going to develop and, you know, how we should understand them. So,
Hobby Lobby.
well, yeah, no, all of
There's,
it.
there's another issue, which is a demographic issue, which it seems that the push toward codifying fundamentalist religious beliefs is proceeding at a time when the percentage of the American population that professes any religious belief is declining. So there is an issue about demographics to me, and does freedom of religion, as the Constitution says, also include an imperative to be free from religion, particularly when the society is moving toward majority non-religious?
Yeah, that's an interesting point, and it invokes the French government's principle of secularity. France, by law, is a secular nation, so that's why France tends to get into legal disputes over banning hijabs or other you know, or yarmulkes, religious accoutrement in general, in public spaces, classrooms, or government offices. And so on this point, France is an interesting contrast because they are expressly by law a secular nation. And that's an enforceable legal principle, which is why they get into those disputes. We're the other way around. We're expressly not a secular nation. We're expressly a religious nation. So, you know, demographics aside, at least the current state of the law is nothing like France's. So that argument does get made, but it.
Although the Constitution, the Constitution does prevent the establishment of a religion.
It does. But it
And
also
so the
prevents the
fact that
government
we
from
are a
discriminating
Christian,
against
that
religion
we're a
in
Christian
general.
nation is cultural.
Yeah.
And the culture bleeds into law, but I think the Constitution's clear about non-establishment of a religion.
Totally. But even if your demographic argument is right, even if you get down to like the last, let's say, Jewish person in America, that the government would still have to protect their free exercise rights.
No, that's true, but that's why I keep emphasizing free exercise, Are we talking sword or shield?
Totally.
I mean, I think that David's point earlier is where the crux is neutral laws, the application of neutral laws to people who have religious objections.
Yeah.
Because that's where the sword is, right? If you can allow people to kill someone for adultery, that's the extreme sword. And, you know, obviously, I don't think that we're anywhere near that. And the difficult thing is figuring out where on that continuum we are, you know, with the other end of the continuum is I don't want to work on Sundays. Or,
That has been litigated.
yeah, yeah. Or dry towns. I mean, I guess if we're talking about state action,
Sure.
I think we have to figure out where on that continuum. I don't think we're going to, right? I don't think we're going to be able to know.
No, no,
so-
I don't think we can.
Yeah.
Think it's shifting as we go. It seems
Yeah.
like that line is moving.
Yeah. One thing that was mentioned, I think it was the chair who said they would like to have a better understanding of the legislature's charge in this study. That is something Chris and I have talked about too. And I think maybe it would be worth like reserving some time in October to talk about that specifically. Because, you know, there's like the prefatory language in the resolution, and then there's the action language in the resolution, and the action, and they don't quite line up because the action language doesn't really say anything about the ERA, but all of the preamble language is replete with it. And the idea of codifying the ERA in California is weird because what that would mean is changing the standard for equal protection. And the other piece, I guess, is the federal government's jurisdictional reach when regulating sex discrimination. That's not an issue for states. So if we were to try to codify the ERA, it might just be that we can't. That it really doesn't make sense. If the ERA is finally promulgated and becomes part of the US Constitution, it'll do what it does. But we can't do what it does at the state level. We can't change the US constitutional equal protection doctrine. We can't change the US Congress's authority over the states. That's why at the outset of this study, we sort of thought, well, what is the spirit of what we're being asked to do, which is create within California law the strongest protections against sex discrimination that we can. And that's where we landed. It's not, you can't line it up. It's apples and oranges with the ERA. But I don't know what else we would do.
Yeah,
But we,
sex discrimination is already codified in the California Constitution. It's already unconstitutional in California. So could we make it more unconstitutional?
no, but we could address some of the issues we did when we were looking at the initial framing about what is meant by sex discrimination. You know, I think the statutory law, maybe the constitutional law uses the term gender, but by
Right.
which they mean biological sex.
Right.
And so it's sort of antiquated and muddled. We could create some clarity.
That might
And
be worth
beyond-
it.
And then the second piece of it is the assignment to go hunting for existing discrimination and disparate outcomes and cure them. We decided to take those two projects on serially, start with the non-discrimination principle, and then you apply that principle to the entirety of California law to look for problems. But like I said, I don't think the idea of actually enacting the federal ERA in California makes sense. I think it's just posturally askew. So we could talk about that more. I mean, you may not be the only one who has that uncertainty in their head, and Kristen and I have certainly talked about it between ourselves.
So we have something at 11, right?
11:30.
11:30. Oh,
Yeah, that's why I was suggesting we could take a coffee break. Also,
yeah.
I want some coffee.
You know, one more point before we leave this topic. I'm glad that we focused our discussion on the religious aspect of this rather than on the gender aspect that just came up in conversation, which is why I'm thinking about it, because I noticed that all the commissioners that happen to be here today are guys. So I would hate for us to have a robust discussion on gender with just a bunch of dudes. That strikes me as wrong. So I'm glad we're tabling that.
Yeah.
I
Happy to talk
feel
more
the
about
same.
religion.
I feel the same way when all you straight people decide where you're drawing the lines for gay people.
You have to represent, Ambassador. Yeah. But anyway, so Kristen, I think we've talked about this before, but my center's done a fair amount of work on religion in general and California's constitutional religion provisions. And so I've done some deep dives on this, and I'm happy to help you with this, and I want to.
Yeah, no, that would be great. I've been focusing more on federal constitutional issues because those are, definitely far beyond what we have any
Yeah.
ability to address. But I need to address California, as I expect that, we're going to be focusing on statutes. So I need to understand the constitutional landscape in California and how it's different. So we should touch base.
Happy to help.
Great.
And I would say that everything Kristen's been doing in this study so far is sort of trying to understand the space we have to operate in. And so that's coming to an end. I mean, there's not much more to say about that. And so I would expect that at the December meeting, she might have some language to present. So we'd have something tangible to look at, because getting the decisions at this meeting, we just lost Commissioner Huebner. Oh my, that's quite a different look.
I'm still here.
I was just gonna say that, we're almost done with the throat clearing stuff, where we figure out like what would federal law and external limits on California permit us to do? And what do we want, what posture do we want to take with respect to those limits? Once we have that guidance, then we're going to get into the drafting. So my guess is December or early next year, we'll have some actual language to look at. There's actually going to be, I should not, on my way out the door, overpromise for Kristen. Because
What are we going to see on this in October?
What are we going to see on it? A reiteration of this discussion, probably. I would guess probably it would be a memo that talks about the question raised here about what is our assignment?
Yeah.
What are our marching orders? And then a direction to go back and read the prior memo, so that at this one, we can make a decision on the range of possible approaches described at pages X through Y of the prior memo. That would be my guess.
Although it also
Okay.
might be.
I was going to say, since we're only functioning as a subcommittee, and I
Yeah.
wouldn't want to bind my fellow diversely gendered colleagues on any of this, could I suggest that you sort of encapsulate the discussion we had about religion and flag the gender issue, flag the what is our task here issue, and then maybe we can unpack those in October when we actually have a quorum and some of our other colleagues.
Yeah.
Well, it might make sense, yeah, to build out a few more things, and depending on how much progress I can make, maybe exploring some of the California constitutional limits related to religion, helping to lay out that, so that background is also set out.
Yeah.
But yeah.
Christian, maybe, why don't you and I talk like early next week? And I don't know how I'd write it in the memo, but maybe like encapsulate the discussion we had, that the sense of the subcommittee was leaning in the direction of some combination of points 3 and 4, but
Sure.
obviously, the full commission has to decide which of the 4 options it prefers as a body.
Yeah, no, and I was thinking about whether or not it might make sense to flesh out 3 and 4 a little bit more, try to find some more examples and help
Yeah.
get a better sense of what that might look like.
Yeah, and I think when you get, as part of like getting a sense of what our actual task is here, that'll help you rewrite, 3 and 4.
Yeah. Yeah. I mean, I think at a certain point we have to fish or cut bait, right? I mean, we could go on forever talking about the sort of the doctrinal constraints on a state's ability to regulate against discrimination, because
I know I could.
yeah, yeah,
Yeah, well, the interesting thing is, there are a lot of different statutory areas with different rules that are built in, some of which, where those religious exceptions are they necessarily constitutionally derived or required? Not clear, but, there's a lot of law there as well. And areas where federal law and state law interact. So we haven't really gotten into those questions, but there's a huge backdrop that's really hard to manage. So, we're not gonna be able to run it all down, and we just are gonna have to decide when we've gotten to the point of pushing past that.
Hopefully we can make that decision in October.
Yeah.
When we can actually make a decision.
okay. Well, and I think the discussion was good. And if nothing else, I could informally suggest to absent commissioners that they watch it. And to derive whatever benefit from it they can, without being bound by it. But I think that in this instance, the idea of a provisional decision, I think, isn't even worth it. I'd rather just present the issue fresh in October without a thumb on the scale. Okay. So I guess we're waiting until 11:30 for our invited guest.
Can we break?
Maybe just take a break until then?
Yeah.
Okay, good.